Hello and welcome to Topic 10, Lecture 1. And in this lecture, we're going to learn about pretrial procedures. So, what are we going to be covering in this lecture? Well, there are many things that happen in a criminal courtroom. And so, in these two lectures, we're going to be looking at what happens in a criminal courtroom. One thing that happens in a criminal courtroom is actually one of the things that most frequently takes place in a criminal courtroom are the pretrial procedures. And the other thing that happens in a criminal courtroom is the trial. So, stage one and stage two. This lecture examines stage one with a special focus on the grand jury and the preliminary hearing and plea agreements. And the next lecture focuses on stage two, the trial procedures. So let's go ahead and get started. Often when we think about criminal procedures, our mind goes to trial. And the trial itself is often what receives the most media attention. So it's no surprise that when we think about what goes on in the criminal courtroom, what we think about is that it's a trial that goes on in the courtroom. But as we know, very few cases actually ever go to trial. In fact, only 10% of all criminal cases end up being tried, actually going to trial. As we know, the vast majority of them do not ever go to trial. And so what that means is that, well, what goes on in a criminal courtroom? There's still a lot of things that take place in the courtroom. Well, the vast majority of the court activity is dedicated to what is known as pretrial procedure. Since so few cases go to trial, it's really critical to understand what these procedures are and the importance of these procedures. And I think that you'll find when you do your courtroom report at the end of the semester, you're going to find that, yes, you may sit in on a trial, but those are actually kind of hard to come about. A lot of what you're going to be sitting on are pretrial procedures. So learning about them, about those pretrial procedures, is actually going to be really useful as you write your courtroom report. So when it comes to pretrial procedures, oftentimes we sort of think about that when an individual gets arrested, that's the moment that the criminal proceedings begin. But as it says there, an arrest doesn't actually begin the formal criminal proceedings. The first document that starts that procedure is what's known as a criminal complaint. And what a criminal complaint is it's basically a sworn written statement to the court by the prosecutor alleging that an individual has committed an offense and requesting the court that an indictment be sought and a prosecution. So it's sort of like that moment before an individual is actually charged with a crime, where there's basically saying, we have a criminal complaint here and we want the court to get the ball rolling. Okay. We're familiar with sort of the steps that take place within the prosecutorial stage. And so, after a criminal complaint is issued, then there will be a grand jury or preliminary hearing. The indictment process, that's what's associated with the grand jury, or the information process, that's the process that's associated with the preliminary hearing. And these are the two processes that are associated with charging a person formally with a crime. Then there's the arraignment, where an individual is brought into the courtroom and told what the crime is that they're being charged with. They are informed of the charges and asked to enter a plea. Once they enter a plea, what happens to that individual is determined. And so if you plead not guilty, that means you're bound over for trial. And so it's like, okay, we're going to trial here. What are we going to do with you while we're waiting trial? And there's a range of things that can happen, from being released on your own recognizance to setting some sort of bail and making that bail, or setting bail and that person cannot make bail because it's too expensive, or bail being denied, and that means that you are not free to go. And then finally, once bail has been set, the individually accused begins to prepare for trial and might potentially engage in some plea bargaining. Okay. And so in this, we're going to be looking at the grand jury or preliminary hearing, spending special time on that, and on plea bargaining. And you can read about the rest of the pretrial procedures in the textbook. However, I did just want to point out just how many people are in jail, bound over for trial because they're unable to make bail or because bail hasn't been set. So let's take a look at that. I just wanted to show you this graph from the Prison Policy Initiative. This is every year they put out the whole pie that basically shows the number of people that are incarcerated in the United States. And the reason I wanted to show this is because we're talking about the number of people who are in jail pending trial. And so, here the green side, this is the people that are serving in state penitentiary, a little bit more than 1 million, which is reduced recently. We'll see if that number continues to go down. And then over here is the local jails. And so you can see that for the local jails, this is the number of people who are convicted. That means serving less than a year usually. But this is, for over 400,000 people are in local jails pending trial because they're not able to make bail. And, similar over on the federal side, 60,000 people, but a lot less because, people are convicted or charged with state crimes much more than they are federal crimes. So anyways, I just wanted to illustrate that the number of people that are in local jails bound over for trial because it's a significant number. Okay, so let's look at the procedures associated with charging the defendant with a crime. So as we know, the charge is selected by the prosecutor. So the prosecutor, based on the evidence, wants to charge an individual with a crime. But since this is a democracy, there is a check on the power of the prosecutorial charge, as we know. And so the goal of the charging process is to ask the question, is there enough evidence to charge a person for a crime? In other words, when the prosecutor is presenting their evidence, is there probable cause to assume that this person has committed a crime? Is it reasonable to believe that based on the evidence that the person has committed a crime? And so that's what's trying to be determined, probable cause. And generally, probable cause is relatively easy to determine in the charging process. There are two types of charging processes that I mentioned on the previous slide. One is known as the indictment process, and that's where a grand jury is used to determine whether or not there's probable cause to charge somebody with a crime. And the other is known as the information process, and it's the preliminary hearing that is used as the process in the information process. So let's take a look at each of these separately. So one of the things I hear most frequently from my friends, because they know I teach criminal justice, they're sort of like, Hankinson, when you hear about grand juries, is that actually a jury? Is that actually a jury of people? And I say, yeah, it is. That the grand jury is actually a jury of people. And it's known as the grand jury because it's large. There's a lot of jurors that sit on a grand jury versus the petite jury, which is smaller, grand, large, petite, small. And the petite jury, that is the jury, the smaller jury, that's actually used for a criminal trial, okay? But bottom line is both petite juries and grand juries are juries made up of people. And so a grand jury is randomly selected, just like other juries, the juries used for criminal trials, the petite juries. They're just selected, those jurors are selected the same way. Generally on voter registration, or not voter registration, driver's license registration and state IDs. Okay. And so for a grand jury, it depends on where you live, but it's between 16 and 23 people are randomly selected to serve on this grand jury. Sometimes the service can be like for a couple of months. You don't go every day, but you might go once every 2 weeks or once a week where you hear these sorts of grand jury matters, okay? And so it is a jury of people. The grand jury plays two major roles, okay? One role that it plays is it serves as this sort of independent investigating body. That doesn't mean that like 23 random jurors like go around investigating crimes. But what it means is that if there is a crime that's taking place, okay, within a jurisdiction, and law enforcement are doing an investigation on a particular crime, okay, they collect that information from that investigation, and then they turn that information over to the district attorney. And then the district attorney will sometimes present that investigatory information to the grand jury. And that's what's known as a presentment. They're basically saying, this is the investigation that we're doing, and we'd like you grand jurors to weigh in on whether or not you think, based on this investigation, that there should an indictment should be issued. Okay. And so police will come, they'll present the information to the grand jurors. The grand jurors will listen to it, and then they'll basically decide whether or not that, that we do think that there's a possibility that a crime has gone on here, and that it's potential that there should be an indictment issued. And so if they say, look, based on the evidence here, there's not enough evidence to have an indictment, okay, and then it just stops there. Or if they're like, that this is there is enough evidence here, then the grand jury will issue what's known as a bill of indictment, okay? Now, that doesn't mean that somebody's been indicted. It just means it's like the first step. In a way, it's sort of like the complaint, okay, as we're going to see, with the preliminary hearing. It's sort of like, okay, based on our investigation, we think there's a crime here, but let's have a preliminary hearing to determine whether there's probable cause to actually charge somebody with the crime. And so that's one major role that the grand jury plays. Another role that the grand jury plays is to determine whether the state's accusation justifies a trial, okay? So it's like, okay, we've got this information. We think that a crime has taken place. We're going to issue a bill of indictment, but then let us weigh in on whether or not that a person should actually be indicted for the crime. And so the bill of indictment is a written accusation of the charges. It actually lists what this person, based on the information from the investigation, what they are going to be charged with, right? And we've seen recently with some of the indictments that have come down against the former President Trump. I'm just using that as an example because there have been these 4 indictments, and the indictments have been in the news, that you could basically see what the charges are and who is getting charged. And so it's a written accusation of charges, and sometimes indictments have a lot of information in them. And it's submitted to the grand jury by the district attorney. And then the grand jury looks at that, and then they make a decision. And they issue either a true bill, and that means that the individual is going to be indicted, or if they issue no true bill, and then there will be no indictment. And so that is the major role that the grand jury plays. One thing to keep in mind about the grand jury process is the grand jury really is the prosecutor's show. The grand jury meets at the request of the prosecutor. There's no judge that's present. The defendant and the potential defendant, the person who's being considered to be indicted, they have no right to be present. The defendant doesn't. The defense attorney doesn't. They have no right to be present. And it's a closed and secret proceeding. So we don't really know what's going on in grand juries. We don't really know who's being potentially indicted. We don't know what the crime is. We don't know the extent of what's going on. It really is a secret affair. And it's a secret affair for a reason. It's sort of like, well, we're investigating a crime. We're deciding whether or not somebody should be indicted for a crime. And, maybe it's just better to keep that behind closed doors. One, because if somebody doesn't know they're being investigated, then it's possible that they wouldn't change their behavior. But also, if you are under consideration for indictment, and then they decided not to indict you, well, maybe it'd be better if nobody knew about it, if it was closed. And so, the purpose of the grand jury is to seek an indictment. But is there anything else that's going on? Well, it does allow the prosecutor to question witnesses as they are bringing those witnesses in front of the grand jury to make the case that somebody should be indicted. It allows them to potentially, if the defendant is called, that the defendant could be questioned secretly as well. And so that the witnesses or the defendant, they're in secret, and so they're free to speak. We don't know what they're saying. It doesn't harm the reputation of the witnesses. Okay. And so sometimes the prosecutor sort of sees it as a trial run before the trial, right? It's sort of like, do we have enough to go here? Okay. And then also that a part of this grand jury process is sort of already collecting evidence to use in trial, right? And we've got that sense from the indictments, from the different Trump indictments. It's like you really have this sense that like Jack Smith has been investigating these crimes for a while, that by the time the indictment rolls around, that they're really ready to go to trial. They've really kind of worked out the case quite significantly. And so that can often be sort of one of the purposes of the grand jury besides just seeking the indictment. So let's move on to talk about the preliminary hearing or the information process. Now, the purpose of the preliminary hearing is the same as the grand jury. It's to determine whether there or not there's probable cause to charge somebody with a crime. It's just that the process is extraordinarily different. That preliminary hearing is not conducted in secret. It is conducted in the courtroom in public. In fact, you might get an opportunity to sit in on a preliminary hearing for your courtroom report. It's conducted before a judge. It's open to the public, and all are present. The prosecuting attorney is present, the defendant, and the defense attorney. And then basically each side presents evidence to the judge. It's like a little mini trial before the trial. Evidence is presented, the evidence is questioned, and that there is after that presentation of that information associated with the crime and trying to establish probable cause, then the judge decides whether there's not probable cause and the charges should be dismissed, or if there is probable cause, and if so, then that individual would be bound over for trial. And it's the information, that's the document itself, that's the formal charging document, okay? So sort of like an indictment is that formal charging document. In the preliminary hearing, it is known as an information. I will note that the Fifth Amendment in the Bill of Rights does mention an individual's right to a grand jury. However, you should keep in mind that that only applies to federal cases. That provision of the Fifth Amendment has actually never been applied to the states. And so some states, well, if you are under a consideration for federal charges, then a grand jury, you have the right to a grand jury. And usually federal cases are, the charging process is the grand jury process. But at the state level, you don't necessarily have a right to a grand jury. It really depends on the state that you live in. And in Wisconsin, for state offenses, the process that's used is the information process, the preliminary hearing for state cases. So you very well may see this when you go to the courtroom. Okay, so some things to think about are just like, what are the benefits of the grand jury? Are there any potential drawbacks? What are some of the benefits and drawbacks of the preliminary hearing? And, maybe think about if you were facing charges, which would you prefer? Which process would you prefer as a person who is facing charges? Would you prefer the preliminary hearing process or the grand jury process? And if so, why? And do you think one of the two systems is fairer? Do you think the grand jury process is fairer, or the preliminary hearing process is fairer? Just some things to think about as you're learning about these two processes. So after you are charged with the crime, the next step in the process is the arraignment. So once charged, that in a democratic society, you must be told what the charges are, okay? In order to defend yourself against those charges. You can't provide a defense against yourself if you don't actually know what the criminal charges are. And where you learn about those charges is that it happens at the arraignment, okay? And so we're familiar with what happens at the arraignment. It's at that point where the judge informs the defendant of the charges. They ask the person if they understand the charges, because the Sixth Amendment tells us that you must be competent to stand trial. And so, and you also have to be competent to enter a plea. And so if you are incompetent at your arraignment, then that will be taken into consideration. It doesn't mean that it stops there, but that the judge may say, look, this individual doesn't understand the charges, so how could they possibly enter a plea because they're incompetent? And they would stop the arraignment at that point until they were able to determine or get that individual under the proper medication, what have you, getting them off of drugs, whatever is making them incompetent, you getting them competent so they could come back in to actually understand the charges and enter a plea. Because if an incompetent person enters a plea, then it's completely meaningless. The pleas are guilty, not guilty, no contest. Most people start the process at the arraignment by pleading not guilty and going from there. You have a right to counsel if you cannot afford it, and so that if you can't afford it, it will be assigned to you. And if there is a no guilty plea, then bail is set, as we talked earlier in the lecture. So let's turn our sights now to focusing a little bit more on the plea bargaining process, particularly since only 10% of cases go to trial. That means the vast majority of those people plead guilty. And so 90% of cases don't go to trial. Most cases result in a plea agreement. And what a plea agreement is an ongoing negotiation between the prosecutor and the defense attorney, okay? And it's a good illustration of the courtroom work group in action, okay? And so the prosecutor generally starts off charging people with many a crime, right? Whatever the probable cause sustains, they're going to go for the highest charges, and this is something that is discussed in the book Locked In. Sort of the unchecked power of the prosecutor in terms of charging people with felonies and really stacking the deck in order to get people to plead down. And so that plea bargaining is this sort of like prosecutors start with big charges and the hopes that it scares the bejesus out of the person who's charged with a crime, and then their defense attorney will work with the prosecutor to avoid trial, courtroom work group, and as a part of that avoiding trial, the charges will be lowered. Okay. Now, the judge is not supposed to participate in plea deals. It's the defendant being represented by the defense attorney. The defense attorney can't make decisions on behalf of their client. They can present offers that the prosecutor has to their client, but if their client doesn't accept it, the defense attorney can't accept it on their behalf, okay? So it's a negotiation between the two sides until they come up to a charge and a potential sentence that both sides are sort of amenable to. Once there's an agreement that the plea deal does go before the judge, and the judge is, they're the ones who accept or not accept the deal, but they don't participate in the compromise and the negotiations between the defense and the prosecutor. Now, and the reason for that is to have impartiality, right? I mean, if the judge is working with the prosecutor or the judge is working with the defense attorney, right, then it might seem like the judge probably wouldn't work with the defense attorney, but they would be most likely to work with the prosecutor, and that would sort of stack against the deck against the criminally accused. We saw a really good example of a judge not accepting a plea deal with the Hunter Biden case. And so you might have remembered from a couple of months back that Hunter Biden, he was charged with lying on when he bought a gun. He said that he had not used illegal drugs. In fact, he had. he lied in the course of an investigation, that was found out, and that he struck a plea agreement to a lesser offense, which both sides agreed to. But then on the day that they went to sign off on the dotted line with the plea agreement, the judge refused the plea agreement, and the plea agreement was canceled, and now Hunter Biden is he's been, the charge remains, and he's, likely to go to trial since the plea agreement was abandoned. Okay. So it does happen. It doesn't happen very frequently, but the judge is the one who ultimately agrees or does not agree to the plea agreement. So as I mentioned on the previous slide, probably the biggest thing that happens in a plea agreement is that charges may be reduced to those of a lesser offense. Again, to go with the examples of the recent Trump indictments, Trump's been indicted, but particularly in the Georgia case, 20 plus people have been indicted for engaging in sort of racketeering activities, which are very significant charges for, promoting that and pressuring the state of Georgia to overturn the results of the election in Georgia in the 2020 election. And so many people were charged with that. And there have been some blockbuster plea agreements that have gone on, not with Trump, but with some of the people around him in his orbit who have been charged. And the main thing that's happened is they've taken these significant charges, oftentimes felony charges associated with racketeering, and they've reduced those charges to a lesser offense, either to a non-felony or to a lower felony. If you get a lower offense, you're going to get a lower penalty, okay? That they may reduce the number of charges. You might have had 5 charges against you, and as a part of the plea agreement, they'd say, okay, we're only going to charge you with one thing. It's going to be a lesser offense. That they may recommend a lenient sentence, such as probation, with the hopes that the judge will take that into consideration. And they may agree to charge with a less negative label in exchange for a guilty plea. So rather than being charged as a sex offender, you might be charged with aggravated assault. And even though the offense was the same, it's going to keep you off of sex offender lists, and people might be eager to plead guilty to that in order to avoid that negative label. Clearly, there are some beneficial aspects of plea bargaining that we know that there are a lot of cases that go through the courts. We know that a lot of people are charged with crimes. And so plea bargaining can reduce the overall cost of the system because it avoids trial, and trial is extraordinarily expensive. That administrative efficiency is increased because there is less of that administrative hurdles associated with trial. And that if people plea bargain out, particularly the less serious cases, then more time can be devoted to the more serious cases. On the flip side of that, clearly most everybody pleads out, okay? And so that really, sure, a lot of those people probably guilty and probably happy to get a lower charge and a lower sentence. But it does raise the danger that an innocent person will plead guilty because they're poor, a minority, they can't make bail, they want to plead guilty in order to, get out on probation and resume their life, okay? And so that does happen, and that is cause for concern. It also may encourage a defendant to waive his constitutional right to a trial. A person might really not be guilty, but they don't trust the trial system. They assume that their chances of being found guilty are high, which they are, and so they might just say, screw it, I'm going to waive my right to a trial. I'll take the 10-year sentence rather than taking my chances with the jury and ending up in life without the possibility of parole. And so that's always a possibility as well. So in conclusion here, just keep in mind that there are some legal issues associated with plea bargaining. If you're engaging in plea bargaining, you must have effective counsel. If your counsel is not good, the defense counsel is not good, then the plea agreement is not good. An individual cannot be pressured by the prosecutor, by a judge, by their defense attorney to take the plea agreement. The agreement, the acceptance of the agreement must be voluntary by the person that is accused by the accused of the crime. If prosecutor makes a promise that if you plead guilty, we'll do X, Y, and Z, lower the charges, recommend probation, etc., the prosecutor must follow through. Okay, they can't say that to get you to plead guilty and then be like, haha, switcheroo. Okay, that is not allowed. So the prosecutor must keep its promises. And as I mentioned, that the judge cannot be involved in the process beyond the approval or the denial of the bargain, because we need to make sure that this remains an impartial process. All right, that's it on pretrial procedures. Thanks for paying attention, and I will talk to you in the next lecture when we learn about the trial procedures. Talk to you again soon.